You're watching Capitol Connection from the Illinois State Capitol.
Welcome back. The U.S. Supreme Court sidestepped a lawsuit challenging qualified immunity in March. Could the State House take a closer look at ending that practice here? The federal judicial doctrine says that government workers have immunity to do their jobs with the qualification that they carry them out in good faith. It does not block police from criminal prosecution, but for as long as that shield has been up, many of the civil lawsuits against police officers have largely been tossed out, leaving the courts with precious few cases to consider as precedent. That buildup has flustered and frustrated people that brought cases against officers. Joining us now to take a closer look at what qualified immunity is and what the debate to end it might mean is a former prosecutor and current state representative, Republican Patrick Windhorst. Good to have you with us.
Good to be here. Thank you.
We visited with you when the police reform bill was passing that it would end cash bail and do much of that. I understand there are still discussions going on about how to improve or tweak some of that language. But on qualified immunity itself, why should a police officer have that sort of carte blanche automatic blockade that would protect him or her from a civil lawsuit?
The purpose of the doctrine is to avoid police officers being held liable for things that are considered honest mistakes or things that weren't clearly established in the law before they occurred. And that's essentially what qualified immunity does. It prohibits a successful suit for someone who has not had a clearly established constitutional right violated.
Do you believe that practice has been abused or overused?
Well, in committee, when we discussed this bill that Representative Tarver's put forward, there was some studies that were referenced that say that it's only successful in about 4% of cases when it's raised as a defense. So I don't think that it's been overused, but I do believe it's something that the federal courts should take a look at, and perhaps even Congress, because it's a court-made doctrine. The U.S. Congress and U.S. Senate can take a look at enacting legislation that would address it.
That's an interesting part. I know more people in the public are hearing this whole, this mantra, this motto to end qualified immunity, but what is it exactly? You sort of hit the nose on the head there, that it is not exactly statute. It's not written in state law. So writing it into state law right now that Illinois is going to end it, what effect would that have?
Right, so qualified immunity is a protection that occurs under what are called Section 1983 cases in federal court. It's not a defense in any state court action because there isn't a state court cause of action. That's what this bill would do, is create a new state court cause of action. The belief of those that are opposing it is that because it's a federally mandated doctrine, a court mandated doctrine for federal cases, that the resolution or the solution should come from the federal jurisdiction.
Do you think prosecutors have hesitation bringing charges against police officers?
I would say that that is a fair statement. I think that that is changing, and obviously we've seen in the news some of the recent cases that is changing. Most prosecutors I deal with have the philosophy that no one is above the law, that the law is to be applied equally, and that similarly situated people should be treated the same. And that is a philosophy of our justice system, and I believe that we're seeing that become more appropriately applied.
We have heard from police officers as well, the Sheriff's Association, others who have looked at a lot of the rising scrutiny applied to police officers and said, okay, they acknowledge now, maybe there has been this code of silence or a culture of silence in the past where the boys in blue would sort of circle the wagons and protect each other, but they say that now they're ready to change that. Could we have gotten here without the public pressure campaign?
That's difficult to say. I think it's important for people to have their voices heard, and it's clear throughout the history of our country that when people have their voice heard, they are able to enact positive change. Now, that to me is how you have your voice heard, is you speak with your legislators, you have peaceable demonstrations, and you educate not only our elected officials but the public on the issues, and that's how we drive change.
Mm-hmm. Yeah, these matters of law and life, protecting life, are increasingly a part of our public discussion as many of these episodes are caught on camera. First, I take you to mean when you say you want federal Congress or maybe federal courts to look at qualified immunity, you don't believe it should come up here in the State House. Do I read you correctly?
That's correct. I don't believe this bill is appropriate. Number one, we had the Safety Act, which just passed, which had a task force for the study of qualified immunity. Mm-hmm. That task force has not issued a report. I don't know if that it's even
it has
met
not.
Yet.
Its members have not yet been appointed.
Correct.
So that's slow to get out of the gate. So you want to see action elsewhere. I think Senator Durbin is perhaps looking at this. He chairs the Judiciary Committee in the U.S. Senate and very well may take a closer look at that in Congress. But I do want to get your perspective. Have you seen the video of the shooting of Adam Toledo in Chicago?
I have, yes.
Should that officer face charges?
Well, I have only seen the video. There's going to be more to that case than just a video. The video is a very important and powerful piece of evidence, but an investigation is often more than just a video. And I think it's important that we let that investigation reach a conclusion and then an appropriate decision is made. It's important that we wait for evidence or collect evidence before we make a snap decision on certain things.
Part of I hear a measured response from you. I think that maybe that was built up in practice over years as a prosecutor. You want to wait to see the full body of evidence. I don't know that the general public has acquired that muscle memory of patience when viewing those searing images in a video, and perhaps the rise of police body cameras, the rise of the internet itself, takes these moments, these dramatic moments, and just spreads them out far and wide. That must complicate the effort to adjudicate these issues or examine them in court, but maybe there's an upside too, that more people are seeing what actually happened.
It is important that the public knows what occurs and the public's informed and aware of what occurs. It's also important that we have a court system that metes out impartial justice, that is fair to everyone in our country. And the court system exists as a way for us to resolve disputes and to enforce the law in a way that is fair and equal. Mm-hmm. And that's the way it should work. It is also designed to avoid snap judgments or heated judgments. It's designed to weigh and evaluate evidence and make decisions based on that evidence.
What did you make of the jury's verdict in the Derrick Chauvin case?
You know, I did not get to see the entirety of the trial, so it's difficult for me to say exactly, but I do trust a jury sitting there hearing because I did not hear all the evidence. A jury sitting there hearing all the evidence, hearing the arguments of both sides, trusting that jury's verdict, yes.
An alternate juror who did not sit on the panel but was in the room felt that the defense attorneys did not prove what they said they would set out to prove in the case, that they fell short basically of their opening statement.
And that's often, not to get too much into how court cases are resolved, but jurors tend to hold attorneys to their statements in court. If an attorney promises something and doesn't deliver, that's typically held against the attorney or their client.
I thank you for discussing this sensitive issue. I also want to discuss quickly if there is any update on what the Safety Act as it's known, or many of our viewers will recognize the discussions we've had around the push to end cash bail, to increase accountability and monitoring of police officers on the job, to expand the way people can file complaints, internal complaints against police officers anonymously. Republicans, including yourself, had a number of issues with the way this was thrown together.
Yes.
What's the status update? Have there been any new developments on that front?
There have been discussions. My understanding is that there's information and suggestions that are being gathered, and that there's likely to be some legislation this spring to deal with some of the issues.
This session?
This session, yes.
Okay, and there are several years before this is fully implemented. It would not all take place immediately, so you have ample time to
For some portions, for some portions, yes. Some are effective in January, some are even, I believe, July 1. So depending on the part of the bill that's affected, it's, I think, important that we work this spring to deal with it.
All right, House Republican Patrick Windhorst, a former prosecutor, joining us with insight on what it might mean to end qualified immunity and other police reform measures. Thank you for joining us.
Thank you, appreciate it.
We're back in just a moment with Senate Democrat Steve Stottleman with a look at local news, his push to revive a dying industry.